Okay, Lincoln, the recording has started.
All right, thank you. Good morning. So this is a hearing in the matter of the encroachment permit application number L95S047B. And it's regarding the John Gaila Condon Living Trust as the applicant for the permit of a single boat dock. And so were several objections to the building of that dock filed. And so we're having a hearing about that today. So the way this will work is we'll first give Mr. Condon. Am I saying your name correctly? Is it Condon or Condon?
Condon.
Condon. Okay. Thank you for that. So we'll first give the applicant, Mr. Condon, a chance to give some testimony on this hearing to explain his application and anything that he wants to say about it. And then we'll hear from the objectors regarding their concerns and the objections that they filed. And then we'll hear from the Idaho Department of Lands and go from there. So I just want to note that I'm here in Boise, Idaho. I have the case documents in front of me. And so if you see me looking off at an angle or in the distance, so forth, I'm looking at the different documents regarding the case in terms of the application, the statement that Department of Lands submitted as part of their consideration of the application and for this hearing, as well as the objections, and then any rules that govern this area of law regarding single family boat dock permits and their criteria that goes along with their approval and so forth. So I also have some notes here on my desk, and I'll occasionally take notes as we go along. And so that's pretty much how the process will work. Anyone considering speaking on the hearing today is we think of as a witness, and we do swear in witnesses before we take testimony. So don't want that to throw anybody off, but that's just part of the procedure here. If anyone needs a break at any time, or if you can't hear what's being said or something like that, please speak up and let me know. We want this to be an orderly participation where everyone can participate and to the issue at hand, and that is whether the single family boat dock permit meets the application, and if there's any valid objections per the rules that would lead me to recommend it being denied. And just so you know, the result of this hearing is I write an order within 30 days from today's hearing date that is a recommendation to the director of the Department of Lands, who ultimately has the final authority on whether this application should be approved or not. So with all that being said, let's go ahead and get into it, unless there was anything we needed to discuss before we get into the hearing. Ms. Kaufman, I'll start with you first with Department of Lands. Anything we need to cover before we get into testimony?
No, sir. Thank you very much.
All right, thank you. All right, so with that being said, let's go to the applicant first, and we can talk a little bit about the application. Then we'll hear from the objectors, and then we'll hear from Department of Lands. And as the hearing officer, I may ask questions from time to time just to understand what's being said, or if I need a little more detail about something, then I may ask that question, just fair warning. So Mr. Condon, let's start with you. Do you swear to tell the truth, the whole truth, and nothing but the truth today?
I do.
All right, thank you so much. So I do have the application in front of me, and I note that it is for a single family boat dock permit. If you could just explain your thinking of why you submitted that application and what your plans for it are. And then as part of the question, it seems the concern is that you already have some commercial docks as part of your marine operation there, and why you applied for a single family dock as opposed to another commercial dock. I'm sure we would like some more information on that, but now is your chance to say anything that you want to say, and if you get a chance to address that, I'm sure we would appreciate it. So go ahead and begin when you're ready.
Good morning. My name is John Condon. I'm here on behalf of myself and my wife and our trust. I'm here as a citizen of the United States of America and as of the state of Idaho, representing myself in a personal capacity as regards a personally held piece of property. We've never met before, Lincoln. I've been through a few of these hearings, and just before we get started, in the interest of time and so forth, can you also allow me to ask some questions?
Yeah, that's fine.
Okay.
I'm not
So
sure
I
if I'll
would,
be able to answer them, but
And I'm just wanting to educate myself for today's proceedings and for future proceedings. But I'd like to start with an introduction. Like Lincoln, I've met numerous different hearing officers, including Mick and so forth. Can you give me an idea what your background is in this and what your role and so forth is, and so I can get a better idea of what the understanding of the current rules and regulations are as it regards hearings of this nature?
yeah, sure. So as I mentioned, I'm in Boise, Idaho, and I am a hearing officer for the Attorney General's Office and the General Counsel and Fair Hearings Division. And so I've done a fair number of these hearings regarding navigational encroachments, both for boating docks and boat lifts and things of that nature. And so these are not the only type of hearings I do, but I am a full-time hearing officer with the Attorney General's Office. And so, as mentioned, my understanding of this proceeding is to one, review the application, and if the specs meet the requirements of the law, which is basically the Lake Protection Act. And so I know the document that was submitted by the Department of Lands, they made a statement regarding their findings on how the law applies to the specs of this dock. And so my recommendation will be to the Director of Lands of whether I feel the permit should be approved or denied. And in the written order, I explain why. And as part of that, I consider not only the application specs, but also the rules that apply to it and the objections to it, as well as any other factors that may come into play. Did that answer your question?
To a degree, yes. And I just want to further introduce myself in that I am not a currently licensed attorney in the state of Idaho, so let that be understood. But my knowledge basically comes from being a party to several of the rules committees as they apply to the rules of the state waterways and so forth, and the rewrite on several of the rules. So I'm somewhat intimate with the proceedings and the rule making, but I'm always open to learn more. And so that's why I would ask in general, and just if you would just give me the cliff notes, if you will, because I'm fairly simple-minded and would like just a brief explanation of why I'm sitting here today.
Right. And so when your application was submitted to Department of Lands, there's a time period that objectors can file an objection to that application, and usually it's required to be adjacent neighbors to where the dock will be located. And so they have to do that within a certain time frame of the application. And so 2 objections were filed as part of your application, and in doing so, they may request a public hearing on the matter. And I don't know if you've received all the case documents, but in terms of the letter that was sent by Department of Lands to some of the adjacent neighbors, one of the options is for them to request a hearing, a contested case hearing and a public hearing to discuss the matter. And that was done in this case, and that is why we're sitting here today.
But in fact, neither of those were the adjoining neighbor.
Right, and that was one of my questions as well, because I understand it seems like to the one side of your property is vacant. I don't know if it's owned or just vacant. And then seems like you own the other side of the property that has your existing marine operation. But to my knowledge, I don't know that they have to be an adjacent neighbor to request a hearing, in which case Department of Lands could still grant a hearing even if it's not an adjacent neighbor. And let's go to Ms. Kaufman real quick with Department of Lands. Ms. Kaufman, can you add some clarification to that on basically what neighbors have to be notified and how adjacent is defined and so forth, and what would lead to a public hearing such as this if there are objections?
Yeah, so I can try to do that a little bit, Mr. Hearing Officer, and if we get to a factual question about this particular case and the adjacent neighbors, I'm going to defer a little bit to Mr. Amer, if that's okay. So generally, under the LPA and the LPA rules, I think everyone sitting here today understands that they're usually processed fairly simply. But the rule 25.02 of the LPA rules, which is 20.03.04 of IDAPA, does provide that the department will provide a copy of the application to littoral owners immediately adjacent to applicant's property. And then if the applicant owns one or more adjacent lots, then the department notifies the owner of the next adjacent lot. So, and I can have Mr. Amer talk a little bit about that component of it. And then, but before he does that part, if the adjacent littoral owners who've been notified under that rule file objections, then of course the hearing is set, and you're correct that the department may request a hearing as well. Now, the department did not request a hearing in this case. The hearing was because of the objections that were filed. So Mike, do you want to talk just a little bit about the neighbor notification and the adjacency issue in this particular case?
Mr. Hearing Officer, oh, go ahead.
Yeah, and real quick, Mr. Amer, do you swear to tell the truth, the whole truth, and nothing but the truth today?
Yes, I do, sir.
All right, thank you. Go
It
ahead.
is our policy and procedures to essentially hop over a littoral owner until we get to somebody else. So in this case, John and Gaila Condon own 3 lots along the southwestern shore of Hayden Lake. And so when we do the neighboring notification, we essentially hop over those John and Gaila Condon lots until we find a different owner. And in this case, that next adjacent owner is Dalton Gardens Irrigation District. It's a fairly common practice we do, because it's not that uncommon for people to own multiple lots. And so instead of notifying themselves of their project, we skip them until we get to a different owner, different littoral owner.
Got it. All right, thank you. All right, so Mr. Condon, let's go back to you. I hope that addressed your questions. Do you have any other questions?
So it does, but I'm not quite ready to move on from there yet. So is that basically a practice, or is that actually just someone's interpretation of the rules? Because when I hear the rules read, it says the immediately adjacent property owner, which we have may use on one side, who have not made any complaint. And then we go the other direction, which is me, and then the water district. And that being said, was that vetted as far as the complainant from the water district? Was that party that complained actually speaking for the water district or for themselves personally? And if they were speaking, do they have authority to speak for the water district when they made that request?
Mr. Hearing Officer, I would just note again that the rules provide, in terms of the irrigation district, it says if the applicant owns one or more adjacent lots, the department shall notify the owner of the next adjacent lot. That's in rule. That's what Mr. Amer just talked about. That's why the irrigation district was notified. And also, I don't think we have anything in the record to indicate that the person who signed on behalf of Dalton Gardens lacked any sort of authority to register the objection that they did. And I don't think, the notice was sent to the Dalton Garden Irrigation District's, what I understand to be their official address. if there is some specific evidence that the Dalton Gardens, the person speaking was not authorized, that's fine, but I think we have to assume that the person who spoke was authorized to do so. Or the person who signed, filled out the objection form. Sorry, I spoke there.
Okay, and let me ask now, is someone on the line from Dalton Gardens?
Coming back from you. We have him in the hearing room,
Okay.
Mr. Hearing Officer.
I'll scoot over
Okay.
so you can see him. He's behind me.
Okay, yeah, I can see him. Okay, thank you. So, I mean, that's something we can discuss more when we get to objections, to hear their concerns. And Mr. Condon, I should say, you're not required to say anything further about your application. It's just an opportunity for you to say anything that you do want to say. Was there any other concerns you wanted to address before we talk about your application itself?
So a couple things. One is that I would like to go on record questioning the authority of the party that responded on behalf of the irrigation district. I think for those kind of formalities, it would either have to be described in their and have a record of their authority to do so, or would have to be voted upon by their board. So I would like to go on record as contesting that. In addition to that, I have a few other questions. One, a compliment, because this goes back to something that I requested on 3 occasions through a state representative that parties that would speak at public hearings would be sworn in so that they could be held accountable for their testimony. When did that practice begin?
That, to be honest, I just don't know. I can tell you I've been a hearing officer since 2015 and I've always done it. And it's, to my knowledge, pretty common in administrative hearings to do so.
So in my experience, it hadn't been done so, and I applaud you for doing so, and that is certainly a move in the right direction to help curtail these frivolous claims and so forth by parties against a party that is merely exercising their privileges and rights as a citizen to apply for. And thank you for and the Department of Lands for allowing me to apply for this dock permit encroachment upon the public waterways. So I just want to go on record as thanking you also for that privilege and opportunity. That being said, there's a few other things that I want to go on record in addition to that, and certainly on the lines of an effort, and certainly in this state about tort reform and so forth, that when a party brings a complaint against a party that is looking to exercise their rights, that if the prevailing party in fact prevails, that the complainant should be held at least financially responsible for the costs of these hearings, and especially if they really have no standing or no legitimate reason for calling a hearing. Because I can only say that for myself and the amount of time, energy, and money that I spend in these kind of hearings, I know that your own staff at the state, who is already understaffed, there should be some ability to recover costs if frivolous complaints are brought forward. So I'd like to at least go on record stating that. I'd also like to go on record and state that everybody in the room understands that there was a pre-existing previous dock permitted on this very site. And that thirdly, that my other operations on other parts of the lake, in other parts of the world, have no bearing on my application today. And as you aforementioned, that I should assume that the party that exercise that complaint on behalf of the water district, I should assume they had authority to do so because by rule of law in Idaho, in the United States, that one is essentially assumed innocent until proven guilty. I would like to go on record and say that I would also like to be given that same privilege, that I am here today innocent until proven guilty, unless there is some evidence that should give me reason to think that I shouldn't be given that privilege.
Well, let me just note that this is an administrative proceeding. It's not criminal or civil. It's not a question of innocence or guilt. It's whether your application meets criteria for approval. And it seems like the main concern is that you're going to use it for something other than a single family dock, considering that you have commercial docks next to it.
So that question has been asked and answered by staff. Once again, to make that assumption. And if I'm getting a single family dock, the language is already within that permit to address what we're talking about today. So to make an assumption that I'm going to willfully violate that is assuming I'm guilty until proven innocent. And in fact, I am still innocent until proven guilty. So for parties to come forth and make assumptions like that, they should be held accountable. That's what I'm saying. And I'm here today. I'm here like I prefaced, I'm here on behalf of myself and my wife. We have 3 lots there, 2 of which are used for the commercial application, one of which we own privately, and we wish to put a private dock on our privately held property. You know, I also own commercial property on I-90. I own many different other commercial pieces in the area, but that doesn't naturally then assume that I'm going to use my private residence as a commercial operation. I think, you know, all I'm asking is that this is considered on its own merit and that no assumptions be made that I might willfully violate the rules of a permit as written. I may have more to follow, but for now, I'm just, I suppose, venting the reason why, you know, in the Kootenai County, there's close to 4,000 encroachments. And that the majority of those are private single family encroachments. And they are issued for such. And they are enforced for such. And once again, I am baffled why I am here today in a hearing when all I've done is ask for the same privileges that every other one of these parties has asked for and been granted. And that's all I have for now. Thank you for listening to me, Lincoln.
You are welcome, and you'll get a chance to talk again after we hear from the objectors and the Idaho Department of Lands. So you will get a chance to talk again if you have anything further to say, okay?
Thank you.
All right, so we brought up already the irrigation district and one, if I could just ask your name, sir, who's sitting behind Ms. Kaufman, that filed the objection on behalf of the irrigation district.
Yes, it's Robert Weist. I'm the water master for Dalton Irrigation District. I'm gonna get the address.
And would you mind spelling your last name for me, Robert?
W-U-E-S-T.
Okay, and Weist, okay. And do you swear to tell the truth, the whole truth, and nothing but the truth today?
Yes, I do.
Thank you. And are you the one that submitted the form objecting to the proposed single family dock?
Actually, it was the clerk that did it, the office manager that put it in, and I'm here to speak. And the board on Monday night, okayed me to speak
Okay.
here, district.
And I note, I'm looking at the form that was sent in now, stating the objection. And it just said two things of no public access and then not safe. Could you expand on those concerns?
Well, that's, right now, we put up barricades on our property right there in front with the approval of Lakes Highway District to stop the parking. People were using our private property and along with Mr. Condon at one time. So we had a survey, we sold them that piece of property under negotiations for exact. And what we're saying is that when we go down there, we park in the right of way for the Lakes Highway District's property, this on the road, and there's no parking there. And so when you add another dock or anything else, and you have people coming, there's no place to park, there's no parking that I know of. So our thing is safety, because the turnaround area is not, there's no turnaround area.
Okay. But your concern with safety is, if I'm understanding correctly, is not the dock itself, but people getting access to the dock? Is that your concern?
That's correct. That we're just exacerbating the problems that are right there at that location. The reason we blocked it off, some lady threw a ball on the, we have that small spillway there, and the district fixed it where they couldn't drown a dog there again, because that got real public. And people were parking in there, and so we put up barricades. We still let people swim and do whatever in the front of it, but we try to keep the vehicle, there'd be 10 or 12 vehicles in there all the time, and this way, now they park out along the road.
Mr. Hearing Officer, in our room, I pulled open the Cooney County parcel webpage, Casey Earth. If I could share my screen, I could show you the location he's talking about. That may help.
Okay, sure.
See if I can do that. Hold on. Hey, Mike, try it now. I tried to share with you.
Yes, it looks like it's working.
Okay, thank you.
Thank you, Mick. All right, so Mr. Hearing Officer, this is the area he was talking about.
Okay.
This is the parcel that's owned by Dalton Gardens Irrigation District.
Okay.
And this is the parcel owned by Mr. Condon and Gaila Condon, John Gaila Condon. And this third parcel is the one that we're here to talk about today, the one that's being applied for a single family dock.
Okay.
And I believe Mr. Weiss can correct me, but I believe what he's talking about are these barriers on this parking area.
Uh-huh.
In the past, public used to be able to park on this whole entire apron, concrete apron. And
Okay.
public likes to swim in this area. And earlier, Mr. Weiss mentioned a grate where a dog drowned was in this general location.
Okay.
Just wanted you to be able to kind of get familiar with what was being discussed.
All right, thank you. But from our view, the proposed dock is to the right of the two existing docks, correct?
Correct, the one that says 2141.
Okay, 2141, so it's in that zone. And so, and I know Department of Lands will speak later regarding your position on the permit, but again, I asked if the objection was about the dock itself or more for the safety concerns of getting to the dock. Correct me if I'm wrong, but that's more a municipal issue for the county, or or the local police or someone that maintains that road, which is not Department of Lands, correct?
Correct.
Okay. All right, and is that all trees, like, it looks like it's brush, I don't know if it's trees or just growth that's on that parcel where the dock would be built, is that correct? I don't know if IDL has done an inspection on the site.
Yeah, we've been out there. Those are trees.
Okay. Okay, well, thanks for sharing the screen, and that helps a lot to get the visual on that. So, Mr. Wiest, let's go back to you.
You'll have a chance to rebut.
Did you have any other concerns?
No, it's just the safety for the, with public and also ourselves, so that we can have a place to park when we go down to check on that spillway and etc.
Gotcha, okay,
Park right there. We don't have a no parking sign. It's during the summer, I pick the time of the day when I go down, so it doesn't interfere with people that are parked against it. Or maritime when they're there parked against it too. But it's just when you start adding more, it just creates more havoc there. The traffic is really bad right there. That comes around there.
okay. All right, thank you. Mr. Condon, let's go back to you. Just, you don't have to right now, but while we're on that topic, did you want to address it while we're on the topic, or you
I
can
would,
address
well,
it
you
later?
got the screen up if you'll allow me.
Sure,
So there's a couple of things I think one should take notice when they're looking at this screen in front of you. One is that you'll notice that the right of way there clearly spells out North Dyke Road. That was previously a county controlled road there. The dike is owned by the Richards family, but the county maintains it with an MOU with the Richards family. And for many, many years, that was a public roadway that you could drive on. I've questioned this before and I've never gotten a legitimate answer as to whether it was legally abandoned or not. And even before the Dalton Irrigation chose to block it off, it was essentially not the Lakes Highway. In fact, the main road is Lakes Highway, but the other roadway that was blocked off was actually a county roadway. So there's, to me, that brings into question even the legality of them to block that off. Now, if you'll also look at the diagram, you'll see the limits of the right of way for Lakes Highway District end at my parcels. Up to those parcels, it is in fact an easement beyond that. They only have prescriptive rights. So they cannot enforce any more than what's been prescribed as the right of way through there, which is no more through my research than the actual paved surface. We in fact have from Lakes Highway District just going beyond and above what we're legally obligated to do. We have permitted approaches there. So we've not only developed our own parking on the lakeside of the road, but we've also got parking developed on the other side of the road. And I would merely suggest that if they in fact need parking, especially for their own abilities to inspect their property, which we've noticed for many, many years now since we've had a presence there, it does not get adequately enforced as far as the use of the property. There continues to be a nuisance there, a potential danger there, because even though there is signs posted there admitting that they have a liable endangerment there, there's ever been any enforcement to keep people away from that outflow and so forth. So it continues to be a potential hazard. If we're really concerned about hazards to the public, i.e. about having enough access or parking area. And two, to go to your point, is that I have a legal buildable lot there. And nowhere in the rules with Department of Lands for a single family encroachment does it even address parking. The only time parking is ever addressed is when it's for a marina where you have to have one car park for every 2 slips. Outside of that, it is not even a question as to whether, you know, and my plan eventually is to build a home there. And I believe I'm well within my rights to do so. I purchased that lot specifically for that purpose, so I could maintain some buffer between the other adjoining property and those other operations. Currently, I don't use that lot for anything other than a buffer. And at this point, it is my desire, my wife's desire, merely to be able to build a home there. And so that's why I guess maybe I'm overreacting a little bit, but I really feel like my rights here are being violated because there's some parties making some assumptions that are inaccurate, and which they've already, and I think we could in the future curtail a lot of this, you know, these frivolous claims by merely and I believe it's actually been done so by the staff answering those questions and concerns, which I've written down and submitted my answers to those concerns, which should negate the usage of everybody's resources to be in here today. You know, and in the future would make much better time of all the parties here today than to be re-answering the same questions that have been asked and answered. And if that is the only concern we're talking about, we shouldn't even be here today, because that's not even relative to the request. That's all I have for now.
All right, thank you. Mr. Weist, was there anything else you wanted to say at this time?
Yes, sir. North Dyke Road, I've lived here 52 years, and it used to be called the Dyke Roads. When FEMA came in and rebuilt that, they called it the dam. We agreed with them to put the spillway in to keep it from breaching. Back then, before that, people did travel across it, but I've never seen it called the Dyke Road until now. I mean, I think the first time I've ever seen it on the maps. I mean, everybody can call anything they want, but we do own that property. We still let people recreate there because Honeysuckle Beach is overcrowded. We haven't closed it off to the public. Only the access into it. If you look at some of the older maps, you'll see a vehicle on it. All we're looking at is safety. And whenever you get in the paper and you don't follow the safety rules, you get beat up pretty bad. And being a public agency, we're not looking at being in the paper again because of dog drown. Have nothing to do with his dock, though. I just permit the comment as far as I'm just looking at the safety part.
Okay. All right, thank you. All right, well, let's go to the other objector on this, Mr. Snowden. Mr. Snowden, are you on the line?
I do not believe he's on the line, Mr. Hearing Officer, and he's not in the office here.
Okay. All right, well, I have his objection as part of the record, and I should say this, should have said it earlier, but anything that was submitted in writing such as the application, IDL statement, and the two objections and so forth are part of the record here. So Mr. Snowden is the other objector. He submitted a short objection that I'll consider, but he's not here on the hearing to further explain the basis of his objection. So as of now, then let's go to you, Mr. Amer, and we can talk about IDL statement and anything else you want to address based on what we've heard today during this hearing.
Thank you, Mr. Hearing Officer. I'm going to read the prepared statement, and as is customary for Department of Lands, I'm going to skip over the section 2 that talks about all of the applicable legal provisions that were reviewed. Good morning. My name is Mike Amer. I'm a Lands Resource Supervisor for the MICRA Supervisory Area Office of Department of Lands. My purpose in being here today is to provide you with information regarding IDL's assessment of application for encroachment permit L95S 478B, which is application filed by John Gaila Condon Living Trust, which owns property identified as parcel 0-3520-000-138-0 on Hayden Lake in Hayden, Idaho. Applicant is seeking an encroachment permit for a single-family dock located adjacent to a vacant parcel on the southwest shore of Hayden Lake. This parcel is described as parcel ID 03520-000-1380, AIN 107344, lot 138, block 1 of HL Honeysuckle Hills building sites. The proposed single-family dock would consist of a 4x10 pier, 3x15 ramp, 6x21 approach, and 28x24 foot single slip dock comprising 699 square feet. Encroachment permit L95S 478A was issued back on February 8th, 2002 to transfer the original permit to the new owners of the property. The original permit was for a single family dock consisting of a 6x20 ramp and a 20x30 foot single slip dock. For the timeline, on July 13th, 2022, IDL received an application for a single family dock. On that same day, IDL sent neighbor notices to Dalton Gardens Irrigation District and to 2387 East Hayden Lake Road LLC. On July 25th, 2022, IDL emailed applicant a set of questions to help determine if the dock would be used as a single family dock or as a commercial navigational encroachment. On that same day, IDL received an email response to the questions and determined that the application for a single family dock was complete. On July 27th, 2022, IDL received an objection notice from Mr. William Eric Snowden II, representing 2387 East Hayden Lake Road LLC. And on August 1st, 2022, IDL received an objection notice from Dalton Gardens Irrigation District. And finally, on August 15th, 2022, IDL's director issued a notice of appointment of hearing officer in hearing. As mentioned before, I'm going to skip ahead and talk about our analysis. For littoral ownership, applicant owns a vacant property on Hayden Lake, as described above. Type of encroachment, applicant is seeking an encroachment permit for a single family dock. The applicant type would be considered a navigational encroachment. For shoreline length, applicant owns approximately 75 feet of water frontage, which is sufficient water frontage for a single family dock. Square footage of encroachments. IDAPA provides that a single family dock may not exceed 700 square feet of total surface decking area, waterward of the ordinary or artificial high water mark. Applicant's proposed dock would be 699 square feet in size. Line of navigability. The proposed single family dock would extend outward into the lake 70 feet. The proposed dock is slightly longer than the two adjacent docks. However, it is not as long as other docks in the area and would be within line of navigability due to the contours of the shoreline. Distance from littoral lines. IDAPA provides a rebuttal presumption that a single family dock will have an adverse effect upon adjacent littoral rights if it is located closer than 10 feet from adjacent littoral right lines. The proposed dock appears to provide a 15-foot buffer to the west and a 24-foot buffer to the east, which meets and exceeds the minimum requirement of IDAPA. Signature requirements. IDAPA states that only persons who are littoral owners or lessees of a littoral owner shall be eligible to apply for encroachment permits. Applicant is the littoral owner. So for the conclusion, IDL acknowledged, well, first I'd like to add something that wasn't in the statement, Mr. Hearing Officer. I'd like to note that the dock appears to already be on site based on aerial imagery without a permit. As we were looking before on that shared screen that I showed you, there was a dock on that property. Just wanted to make that note. IDL acknowledges that John Condon is the owner and operator of North Idaho Maritime, a dock building business in North Idaho. North Idaho Maritime operates a commercial navigational encroachment on the 2 adjacent properties to the west of the parcel, for which he now seeks a permit for a single family dock. The commercial navigational encroachment is permitted under encroachment permit L95S 5696B, which was issued following a public hearing and final order approving that application. IDL was initially concerned that this current application, if approved, might be used as an extension of the commercial activities previously permitted. IDL sent a list of questions to the applicant to help determine if the dock would be used as a single family dock or used as a commercial navigational encroachment. Applicant submitted responses, which are part of the application packet and which satisfied IDL's request and concerns. The dock drawings that were submitted by applicants appear to meet all of our single family dock standards listed under IDAPA. The proposed dock is less than 700 square feet in size. The proposed dock is within the line of navigability. No portion of the dock is wider than 10 feet. The proposed dock drawing shows at least a 10-foot buffer between the dock and adjacent littoral lines. Based on the application provided and IDL's evaluation of the application in light of the LPA and IDAPA, the applicant's proposed dock meets the legal requirements for single family docks. Therefore, IDL recommends approval of the application. However, if approved, IDL recommends that the following term be included in the encroachment permit. That the dock is permitted as a single family dock. There shall be no commercial activity at the dock, including but not limited to loading and unloading commercial materials, dock construction or dock repair within the littoral space, storage of docks or piling within the littoral space, and storing or parking commercial vessels at the dock. And then you want to add something?
Yeah, just real briefly, if I may. There's been some discussion today about requiring non-prevailing parties or parties who file frivolous objections to pay the cost of hearing. And I just want to make sure that the record is clear that neither the Lake Protection Act nor the attendant LPA rules provide any sort of authority for an award of those costs. So I think everyone is probably aware of that, but I want to make sure that the record is clear in that regard.
Okay. And for my own curiosity, Mr. Amer, if you may answer this, so I'm looking at the application now, and it kind of on page 9 of the electronic copy. You probably, I don't know if you have the electronic copy or the paper copy in front of you, but point is, so the existing 2 docks are to the west, and then if you look to the east, there's like 5 existing docks, like starting in parcel 2387 and 2409. Are those commercial docks or are they single family docks?
Those are all single family docks, Mr. Hearing Officer. So the docks in front of 2387 and moving eastward, those are all single family residences.
Okay.
The dock that's sticking out in the corner there, that is the current commercial dock.
Okay.
And then the dock that's just to the west of that red blob line is the dock that I was discussing is already out in the water.
Okay. All right. And then I had a question. If I understood correctly, there was a previous application or permit that went along with the parcel where the proposed dock is going to be. Could you just expand on that a little bit? Like, why is there a new permit necessary?
Okay, yes. So as I stated in the hearing statement, back in 2002, someone purchased that property and we transferred a permit. There was an existing permit, and that existing permit would have been L95S 478. That was the original permit for a 6x20 ramp and a 20x30 single slip dock. In 2002, the property was likely sold and we transferred that permit. At some point from 2002 until today, that dock has been removed, ownership has changed. And so the new owner is making application for a dock in that location. Fairly common for when people move to a new lot that or move to a waterfront lot, that there's an application for a dock. Sometimes the person's boat doesn't fit in the slip, or they had a different dock design in mind and they request to change the dock when they just purchased the property.
Okay, and for IDL's perspective on the interpretation of the rules, if the dock features are going to change in terms of the measurements or function, then a new permit would be necessary, correct?
Correct. If the footprint orientation changes, then a new permit would be required, or if the use changes.
Okay. All right, is there anything else you would like to say this time, Mr. Amer?
No, sir.
Okay. Mr. Condon, let's go back to you. Do you have anything further to add after hearing IDL's statement?
Couple things I'd like to make clear. One, in the interest of time, is I have an 11 o'clock Pilates and I need to get going.
Okay.
So if you'll excuse me, I'm just joking. Mike's correct in that there is a dock there that we do plan on installing on this property that came from another property that we replaced with a new dock on the lake. We call it repurposing in the industry. The reason it's sitting there, and it's in fact sitting in our work area, which is permitted for us to store docks, work on docks, work within that permitted work area. That at least was the intent, is where that should be. And it would, if it were not for this, the pleasure of this hearing, we would, and had the permit gone as would be typical in the single family permit process, that dock would already be installed on said property. In the meantime, we're all enjoying this experience, so which gave me or forced me to have somewhere to store that dock in the interim. So we stored it while we worked on it with the understanding that we were doing so within our permitted work area. So that's why, in fact, Mike is correct in that the dock is currently there, but it's my understanding that it's within our work area.
Okay.
And I'm more than happy to answer any questions that you may have. I also have Anthony Zito online here to answer any more specific questions, because he's actually the one that processed the permit.
Okay, Mr. Zito, do you have anything you'd like to add?
No, I think he pretty well covered it. Like you said, the dock was brought in from another lot on the lake, and it's just kind of in a holding pattern. We do have to do some modifications to the dock, and so it's waiting there for the modifications to fit the permit once it's approved. And if it's not approved, the plan would be to just dismantle it and remove it from the lake at that point.
Okay. And sorry, I forgot to swear you in. I'm not sure. I wasn't sure how much you had to say or not, but do you swear that what you just said is the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. Was there anything else that you wanted to say?
No, I think that covers it, unless there's a specific question that I can answer.
Okay, all right, thank you. Do you mind spelling your last name for me real quick?
It's Z as in zebra, ITO.
Okay, thank you. Yeah, and I had no questions. Mr. Amer, did you have any questions for Mr. Zito?
No, sir.
Okay. Was there anything else that Department of Lands wanted to say before we conclude this hearing?
No, sir.
Okay. And this is a public hearing, so technically members of the public can speak if they wanted to. Is there anyone on the line who wanted to say something before we conclude? Nope, okay. All right, I will consider everything that has been said during this hearing, as well as the written documents that were part of the record here that were submitted by the various parties. And again, if I didn't make it clear earlier, I'll make it clear now that any written documents, including the application, the objections, IDL statement, and so forth, are part of the record here that I can consider when I'm writing this order. My order will be out within 30 days from today's hearing date. The order is a recommended order, not a final order, and it's my recommendation to the Director of Department of Lands to either approve or disapprove the application. So at this point, we can go ahead and conclude the hearing, and Mick, you can stop recording whenever you get a chance. And Mr. Condon, if we don't speak again, I wish you the best of luck going forward.
Thank you.
Thank you.
Thank you, Mr. Hearing Officer.
Thank you. I'm stopping right now.